G'day, I'm Stephen Page from Page Provan, Family and Fertility Lawyers in Brisbane. Thank you for watching and listening to the Australian Family and Fertility Law podcast. I'm talking about posthumous retrieval and use of eggs, sperm and embryos in Victoria. Well, the topic has two bits to it, retrieval and use. And oddly, I'm going to talk about use first because it really determines what happens with the first bit to a degree. To use in Victoria, you have to have written consent by the deceased to the eggs, sperm and embryos. And even if you've got that, you've then got to get approval from the patient review panel. If you're a couple and you're already going through IVF in Victoria, chances are, as I was reminded recently by one of the clinics, that on the form you've consented to posthumous use. But if you haven't done that and you are having to export the egg, sperm or embryos from Victoria to somewhere else, most likely Queensland or the ACT or maybe overseas. But if you're not in that category yet because your husband has just died or is in a position where he's terminal, in a coma and never going to recover, then you can undertake a retrieval. Now, say husband, I know that there has been retrieval of eggs from a woman or two. I've done lots of posthumous retrieval cases. I've just never had one with the woman having died. All of mine have concerned the man dying. And typically when the man dies, he hasn't signed that consent. So how do you achieve it? Well, the first problem is who does this work? And there's only one hospital, women's, where this is commonly done, and one doctor who commonly does these retrievals. The Human Tissue Act in Victoria governs the procedure, and the Human Tissue Act allows for pre-death, or they describe it as non-responsive retrievals. And the non-responsive retrievals requires first the approval of the medical treatment decision maker, typically next of kin, the widow, or soon to be widow I should say, and the designated officer of the hospital, typically the medical superintendent. Then, once you've got that in place, two doctors have to sign off on it. Each of them has to be at least 5 years admitted, and neither must be the designated officer. And it must be in circumstances where death would occur if the artificial respiration or artificial circulation was turned off. And there mustn't have been any objection to ante-mortem, as they've described it, procedures, the non-responsive procedures by the deceased. So those are the requirements for the pre-death, non-responsive. If the man has died, then there's always the rush to get it done quickly, and depending on how the body is stored and the health of the deceased, it may need to be done quickly within 24 hours. And there's a temptation by lawyers to go off to the Supreme Court and get an order. Generally, that isn't required if the procedure under the Human Tissue Act, I should say, is followed. However, I have seen cases where the man died via suicide and the hospital may require authorisation from the Supreme Court that it's appropriate to retrieve. It's not part of the legislation, but that's one of the practical barriers. And the practical barriers are finding a doctor and finding a scientist. If you line those all up, you can get the retrieval done. You're unlikely to go to court, relying on the Human Tissue Act. And then afterwards, chances are, because the consent hasn't been signed for posthumous use, having to export Queensland, ACT or overseas. Pretty tricky, but I can say it's an honour to help widows retrieve, and we've done that quite a few times. Thank you for watching and listening to the Australian Family and Fertility Law podcast. I'm Stephen Page from Page Provan Family and Fertility Lawyers.